Good morning. Good morning. Welcome, everyone. I can see people coming in right now. I would like to take this opportunity to say good morning and a welcome to everyone to the 2022 Summer Law Institute webinar series. My name is Christy Pagnuti, and I'm the Director of Capacity Building and Engagement at OJEN, or the Ontario Justice Education Network. First off, thank you so much for being here today for the first of several sessions this week. Before we get started, there's a few housekeeping items that I'd like to address before we begin. If you have any questions or comments throughout the session, please feel free to use the chat feature or the Q&A. We will leave some time to answer questions at the end through the Q&A function. If there are any links to be shared, I am joined here today by my colleague Raris, who will post them into the chat. Finally, this presentation will be recorded today, so we'll post the video to our website at a future date. It takes us a little bit of time, but we'll have it up there in hopefully a couple days or weeks. I'd like to start this session with a territorial acknowledgement. I know that people are joining us from across Ontario today. Welcome, everyone. I'm based here in Toronto, and I acknowledge that I am on the traditional territories of the Mississauga of the New Credit First Nation, Anishinaabe, Haudenosaunee, Wendat, and Huron Indigenous people who are the original nations of this land. In addition, I acknowledge that Toronto is home to a large and diverse Indigenous population. While I'm grateful for the opportunity to live and work in this community, and as we begin the Summer Law Institute series and the new school year, we all must remain mindful of broken covenants and of the need to work to make things right with all of our relations. So every instance of acknowledgement is also an opportunity to reflect upon the status of our relations and responsibilities. And as we think about the administration of justice, we are compelled to consider the real impact of institutional justice on individuals, families, and whole communities. For today's webinar session, we'll be discussing intimate images, the internet, and privacy. And I'm very pleased to be joined by Francesca Provenzano and Gabby Verdicchio. Francesca is a lawyer with Spark Law at the Windsor office. After graduating from Windsor Law in 2018, Francesca completed her articles and began working as an associate, gaining valuable experience while practicing in family law and commercial litigation. Since joining Spark Law, Francesca has played a pivotal role with the Reclaim Pro Bono Project, which you'll be hearing more about today. She is passionate about helping victims of technology-facilitated violence and works hard to raise awareness in the Windsor community and beyond. Joining Francesca is Gabby Verdicchio, a second-year law student and currently completing her Master of Social Work at the University of Windsor. After completing her Bachelor of Social Work degree in 2021 at the University of Calgary, Gabby knew she wanted to attend law school to create impactful systemic change beyond the micro level. Gabby joined Spark Law and the Reclaim Pro Bono Project in May 2022 as a social justice fellow to conduct research on the state of the law in Ontario and beyond related to technology-facilitated violence, trauma-informed lawyering, and how to best help victims of online sexual abuse. Please join me in welcoming our speakers, and I'll pass it to you, Gabby and Francesca.
Thank you so much, Christy. I'm just going to share my screen. Okay, so you should be seeing that. Perfect. So as Christy said, everyone, my name is Gabriella and I'm joined by Francesca. We're very excited to be here today to talk about the Reclaim Pro Bono Project and some of the work and research we are doing related to the sharing of intimate images without permission. The term sharing intimate images without permission and the term non-consensual distribution of intimate images will be used interchangeably throughout this presentation and are synonymous. So if you hear both of those terms, don't fret, they mean the same thing. Although the term revenge porn is popular and probably what you're used to hearing, we will explain later on in this presentation why we aren't using that term anymore. Because we're presenting to you, we're presenting to educators, we're honing in on identifying the issue and how to mitigate it through prevention and resources. We will also be discussing some of the law around digital privacy and the legal recourse options available in situations where online harm or violence has occurred. As Christy mentioned, the chat's open for questions, so feel free to ask at any time, or you can reserve them from the end. There will also be a small interactive exercise So please feel free to participate in the chat if you feel comfortable. Okay. So what is Reclaim? At Reclaim, we are focused on technology and how the internet has been weaponized to create harm. Fortunately, a lot of this harm has legal consequences, but because it's not like the kind of violence that we are used to seeing or thinking about, it can oftentimes be ignored. The Reclaim Project is a collaboration between the University of Windsor Faculty of Law and Spark Law. It is also part of a larger collaboration aimed at addressing issues of social injustices in online environments. My research this summer took on a more trauma-informed lens, and I focused on the need for harmonized legislation and how lawyers can be more aware of this sort of sexual violence and how they can better help victims. I also looked at the intersectionality of intimate partner violence, the media, and sextortion as an umbrella term. A lot of current cases that I have researched are criminal in nature, as the law around this issue is still new and developing. Civil cases are quite limited for that reason, but we have seen some really important decisions coming out of our court system in recent years. This is something that Francesca will tell you more about in the coming slides. With this in mind, Reclaim is committed to researching and providing educational information on how to address online sexual abuse. Our goal is to raise awareness in our community and beyond by offering information sessions, legal informations, free legal advice when appropriate, and recourse options available to those affected. We want to shift the blame from victims to those who have committed these crimes, and reassuring victims that they are in no way at fault. And so on that note, let's start the conversation. We want to be able to create a safe space, which is why we should mention that some of the information you'll be seeing and learning about today may be difficult to hear. If you need to step away from your computer or leave and come back, that's perfectly okay. This session, as Christy mentioned, is recorded, and we have an infographic with all the relevant information that will be sent to everyone post-webinar. So on our docket today, we'll be identifying the issue, explaining the issue, and ending with some prevention resources and how to rectify the issue should you or your students find yourself in this sort of situation. I know that Christy and the folks at OJEN sent out a glossary of terms prior to this presentation. There may be a few terms on there that were familiar at some point, and some of them may have been unfamiliar. The terms noted on this slide are particularly important and will be talked about directly and indirectly a lot throughout our presentation. Of course, if you are unsure of any of the terms in our presentation today, you can reference the glossary list, or you can put your question in the chat and we can clarify. Great, so I'm going to turn it back over to Christy, who's going to share her screen for a short video. So as I mentioned before, a lot of my research surrounds the media and popular culture and how it intersects with sextortion and online sexual abuse, including the sharing of intimate images without permission. So as you may know or have even watched yourself, HBO released a popular drama called Euphoria. Euphoria depicts a group of high school age students and follows them along throughout their high school journey. The show was praised for showcasing a very raw and real view of high school that most adults know nothing about. The show talks about eating disorders, drug use, sex, relationships, and family issues, all from the perspective of youth. Most notably, the show includes a scene like this related to sextortion and threats to expose private information through intimate images. The dramatization of this crime and forms of online sexual abuse can create a numbing effect, which makes it feel distant, fake, and it blurs the life between online drama and real life consequences. It can also assign negative values to victim sexuality, reinforcing that victims should be ashamed of their bodies. So after watching that clip, we see that Nate is threatening to release photographs that Jules, the blonde girl, sent to someone that Nate was impersonating online. It's important to note for this discussion that we're hoping to have coming up that Jules is transgender and Nate is closeted with his sexuality. So after watching that clip, can anyone maybe share what comes to mind related to the sharing of intimate images without permission and sextortion? It can be a one-word term that you can think of, or maybe a few phrases, whatever you feel. And Christy, I can't see the chat at the moment because I'm sharing my screen. So maybe Francesca or Christy can let me know what people are saying.
I think we're actually hearing from a few attendees that the chat might be disabled. So we'll try to work on that from the back end here, Gabby.
Okay, no worries at all. Maybe just for the sake of time, I'll continue if that's okay.
Sure. Absolutely.
Yeah, perfect. Thank you. Okay. So because the chat was disabled, I'm sure all of you had very good input. I'm going to assume that. Thank you so much. So we see a lot of different things from just a 2-minute clip. We see that there's sextortion, there's sexual abuse, and there's the threat of sharing intimate images without permission. We can also see victim blaming when Nate says that it's Jules' fault that she sent the photos in the first place. Nate does a great job of manipulating Jules and emotionally abusing her. Nate often uses a just world hypothesis with all of his victims on the show, making them believe that they are getting what they deserve. We can also see the intersectionality of how revenge porn and outing also affects LGBTQ IA2S+ youth at higher rates than cisgender youth. Another important thing to note is that the technology use that hides in the shadow of all forms of online, that there is technology abuse that hides in the shadow of all forms of online sexual abuse and harassment. Nate impersonates a youth called Tyler, someone that Jules believes that she can trust and consequently develops a relationship with. Nate is able to remain anonymous through their encounters, while also threatening to release the photos of Jules. Technology use in this instance really benefits Nate because he is able to perpetuate crimes while experiencing little pushback from his victims. Okay. So this clip of Euphoria also dives deep into some of the myths and stereotypes we associate with online sexual violence. All of these myths and stereotypes have been debunked and are simply not true. They carry weight in our society and unfortunately form a lot of the dialogue about online sexual violence, including playing a part in the inception of the term revenge porn. Okay, so you may have heard of the term revenge porn as a common term for sharing intimate images without permission. The term revenge porn is everywhere. It's in the news, it's in our government and legislation, it's in social media, and it's in our courts as well. The use of this term is beneficial, frequency of use does not mean this term is beneficial to describe the facet of online sexual violence. The term revenge porn is harmful for 3 reasons, as you can see on the screen there. So firstly, it's not revenge. Calling it revenge porn insinuates that the victim has done something wrong or has wronged the perpetrator and therefore deserves to have their intimate images shared. When someone posts intimate images without consent or permission, they are not typically doing it as an act of revenge. It is a way to maintain control over the victim and sometimes used as a mean for extortion. Using the word revenge to describe an act that is entirely the fault of the perpetrator is unfair to victims because it purports that victims have done something wrong in the first place and retribution is owed to the perpetrator. Every time the term revenge porn is used, it further reinforces the norms that victims are okay to blame for allowing themselves to be filmed or photographed, and that non-consent is okay when the audience feels like it's warranted. So on the second point, it's not porn. The adult entertainment industry or pornography industry is mass consumed, but very nuanced. On one side, the porn industry maintains a platform for consenting and willing participants to engage in sex work and practice bodily autonomy. On the other side, the porn industry violates the privacy of intimate victims, turning them into objects of pleasure without their consent. The issue with using the term porn to describe sharing intimate images without permission is it warps a very misunderstood harm where the fictional and real become conflated. Consumers of pornography do not know who they are watching. They don't know whether the subject of the porn they're consuming is consenting or if the subjects even know they're being watched. calling the non-consensual distribution of intimate images porn maintains that it is okay to consume and distribute intimate images and videos of this nature. And lastly, it's not entertainment, which kind of intersects with the porn, it's not porn piece. Revenge porn as a term is salacious. Proponents of the term deem it as attention grabbing, so that's why they want to use it. But it's harmful to think about the act of sharing intimate images without permission as attention grabbing. The experience of the victims is very real and happens more commonly than people think. Media outlets often focus on celebrity experiences, but activists and those fighting against this injustice know how common images are shared. So I think most recently we saw one of the Kardashians have this happen to them. It happens truly all the time, and the media does focus on celebrities more than they obviously focus on common real life people. Victims using terms like revenge will only work to victim blame and discourage the sharing of intimate images overall. We should be encouraging bodily autonomy and not limiting individuals' freedom of expression. But we do note that it is the perpetrators that need to be silenced and not the victims. Sharing intimate images without consent is a crime in Canada and many parts of the world, meaning that it is serious and not just something that provides entertainment value or a shock factor. The problem is not social media, it's not Snapchat, it's not sex culture. The problem is a society deeply rooted in patriarchal systems of control and harassment directed at vulnerable individuals. The solution is not to silence victims or blame them, it is to protect their expression both online and offline. Victims of this abuse are your neighbors, your friends, your coworkers, and it is not self-inflicted. So we really believe that small changes in the way that we talk about this form of abuse have really big impacts on legislation and how we protect victims. So we need to change our language to create that meaningful change that we are all seeking. So a little bit of stats and a little bit of the numbers here. We've included these stats to note the average number of social media platforms and some of the ages that are associated with technology and social media use. As teachers, I'm sure you can see just by looking at the students in your classroom and who's on their phones, who's doing what and who's on what platform. So these are 2022 stats from an infographic from TechWise. But yeah, at this point, I'm sure you're all tired of hearing my voice because I am a little bit raspy. So I'll pass it on to Francesca to talk about the law.
Thanks, Gabby. So while privacy rights are still developing in Canadian law, courts and legislation have begun to adapt to changing times, recognizing new criminal and civil actions for individuals whose privacy has been breached. Focusing first on criminal law, a criminal case, as most of you may know, occurs when one party commits a crime under the criminal code and the government, specifically known as the Crown in Canada, pursues punishment on behalf of the public. If found guilty, the accused may face a variety of penalties, including a fine, community service, imprisonment, etc. Criminal law focuses on punishment and retribution. Conversely, civil law, the other stream and the other avenue for recourse for victims of this crime, occurs when one party sues another party in an effort to resolve a private dispute. In civil cases, the most common remedy is damages or money in an effort to restore the injured party to the position they were in before they were harmed. The benefit of the civil justice system allows victims to have more control of the process. Even though money may not undo the harm suffered in these cases, this route is more tailored to the needs of the victim. Although many of the cases today deal specifically with the distribution of intimate images or sensitive information, it can be anticipated or expected that the current law will expand to capture other issues of online sexual violence, including some of those we will be focusing on in the coming slides. So on the slide here, we have a few common forms of online violence. So online harassment, sharing images without permission, sextortion, voyeurism, and impersonation. So I will just run through all of these different areas of online violence. So first we have online harassment, and online harassment is defined as the intentional crossing of emotional or physical safety boundaries, usually involving repeated communication after a person has been told to stop, causing fear and distress. Harassment encompasses a variety of unwanted digital communication. It can involve a brief incident, a single targeted attack, or a long-term organized attack. Women, girls, and gender diverse individuals can be targeted and are more susceptible to being targeted online by people they don't know, and such attacks can often convey threats of sexual violence. So Kaplan and Attis is a civil case that was tried as a result of online harassment, where the court recognized a tort of online harassment. So before this case, you couldn't pursue somebody for online harassment in a civil court. So this marked a critical step forward for victims of serious and persistent online abuse by recognizing this tort. It allows victims moving forward to seek practical remedies that address the harm they've experienced. So for example, an injunction, so putting a stop to somebody posting online about the person who's pursuing this tort. And most importantly, we also have vesting title in posts to the plaintiff. So for example, a court declaring that a picture belongs to that person and cannot be redistributed and posted online. So that's more of a copyright avenue, but the court's getting a little more creative because technology is developing fast, and we need to respond to these harms. Next, we have the sharing of intimate images without permission. We also know it as the non-consensual distribution of intimate images. It presents in various forms, including voyeurism, image-based sexual abuse, upskirting, and sexting. As we know, almost everybody carries a camera these days through their phones. We take pictures, we post them on Snapchat, stories, social media, Instagram. It's a prominent feature in everyday life, especially post-COVID with technology. Social media and instant messaging have made sharing these photos very easy. And when it's consensual, there's no issue. Young people especially are increasingly sharing intimate images, which are often in private relationships with individuals that they trust. And we do want to address, and we want it to be known, that there's no issue from our perspective with people sharing images with people they trust. Like Gabby mentioned earlier, we do want to shift the blame to the individuals redistributing those photos without permission and violating the trust of those individuals who initially shared the photo. In the intimate partner violence context, we often see this as a way to control a victim, keeping them from leaving a relationship or retaliating against them for leaving, which we see in the form of sextortion. And the effect of this distribution is the violation of the depicted person's privacy in relation to the images. Obviously, it can result in embarrassment, humiliation, social ostracization, and obviously many harms, physical, emotional, financial. It obviously creates a lot of issues for a victim survivor. So in response to this issue, the government kind of defined it broadly as cyberbullying and created section 162.1 of the criminal code, which says that everybody who knowingly publishes, distributes, transmits, sells, makes available, or advertises an intimate image of a person without their consent is guilty of a crime under the criminal code. And we've seen this in a few cases. It is relatively new provision in the criminal code, but we've seen it in a few cases, one of which is the Queen and Walsh. We see R.V. Walsh, R being the Queen, the prosecutors, the government. In this case, Mr. Walsh decided to live stream a female who was very intoxicated and nude. He decided to live stream to his friends on FaceTime. And the initial trial court said that because it wasn't a copy, it wasn't capable of being reproduced, so it wasn't a photo or a video, he was not guilty of this crime under section 162.1. It went to the Court of Appeal in Ontario, who said absolutely not. Obviously, a video of somebody nude and a live stream or a FaceTime of somebody nude has the same harm in the sense that it can still be screenshotted and this person is still being broadcasted nude without their consent. So ultimately, Mr. Walsh was convicted. And on the civil side, which with respect to at the bottom of the slide here, we have a couple of torts. So Mr. Walsh was convicted in a criminal court, but the victim here could have pursued the torts of public disclosure of private fact and breach of confidence, which are civil avenues. So again, ways to be compensated financially for the harm and involving the breach of somebody's confidential information where it's not meant to be publicized. So Mr. Walsh being convicted criminally is a step in the right direction, but ultimately there's also the option to pursue financial compensation against Mr. Walsh in this example for harm suffered under these torts. And we'll discuss a little bit more about the civil side, I think, on the next slide. So then we have sextortion, which is when an individual has or claims to have a sexual image of another person and uses it to coerce a person into doing something they do not want to do. So sexual extortion has been now named sextortion, by threatening to release the image unless the other person does as they're told. The person claiming to have the image is able to obtain additional sexual images or information, unwanted sexual activity. Again, it can be used to keep somebody in an abusive relationship or prohibit somebody from leaving. It can happen in a variety of contexts, obviously very powerful and very problematic. The LGBTQ community are particularly susceptible to sextortion if they're concealing their gender identity or sexual orientation. Threats to out their sexual orientation and gender identity can be particularly disturbing, and this can be used in that way as well. The publication of private sexual material has clear ramifications for women and girls as well, but other forms of private information can cause harm if distributed online. Perpetrators of gender-based violence have published private information about a person to harass, embarrass, harm them, or harm the reputation of their targets. And on the civil side, we have this case here, Jane Doe and Morgan. And in this case, the court recognized the tort of public disclosure of private facts. So the court recognized that somebody should be financially compensated for suffering this kind of a harm. So in this case, Jane Doe was in a relationship with Mr. Morgan, and he told her if she left that he would ruin her life and post videos and pictures of her. Surely enough, he was very abusive. She did leave, and he did post a video of her online, a pornographic video of her without her consent. And by the time she discovered it, unfortunately, it had already had some 60,000 views. So Jane Doe sued under this tort, and in order to satisfy the court that she was harmed under this tort, she would have to satisfy that Mr. Morgan publicized an aspect of her life without her consent, and it was highly offensive and not of any concern to the public. In this case, Jane Doe was awarded $100,000 for this harm. Of course, that's probably not going to be enough in the sense of harm being undone, because there's different types of harm as we've discussed, and it just may never be enough for victims, but it is a step in the right direction. So at a time of exponentially accelerated technological advancement, the decision confirms that Ontario courts are willing to adapt common law principles to reflect the modern reality in which privacy interests operate. Further, it demonstrates a strong willingness by the court to recognize new torts that address the injury or harm arising from an invasion of privacy. This could be one avenue of recourse for individuals who have private information or images of themselves distributed without their consent. We have another tort as well called intrusion upon seclusion, which is a similar tort of privacy in the context of distribution of intimate images. And in this case, the defendant's conduct has to be intentional or reckless. The defendant has to invade the private affairs of another person, and a reasonable person would find it highly offensive. So if those elements are satisfied, somebody can pursue a civil suit under the tort of intrusion upon seclusion. We also have voyeurism, which is defined as a person surreptitiously taking photos or recording a video of another person for a sexual purpose. Voyeurs will often use hidden cameras to secretly take photos of victims without their knowledge. Some cases live streaming recorded images to an audience. The images may be captured by a camera hidden in a private place, like a washroom, or the images may be taken in public places using discrete photography techniques. The images may be kept for personal use or shared on public websites. Voyeurism is contained in the Criminal Code under Section 162, subsection 1. And an important case of voyeurism is the Queen and Jarvis, RV Jarvis, as we see on this slide. This actually went all the way up to the Supreme Court of Canada, and the Supreme Court had to decide whether a male high school teacher who secretly filmed his female students' breasts with a camera pen had violated their reasonable expectation of privacy. So as I mentioned, Mr. Jarvis was a teacher. He had a pen with a camera and was taking videos of young students' upper breast region. And the court was tasked with deciding whether or not those students in a public place at their school were retaining a reasonable expectation of privacy. And in this case, all the way up to the Supreme Court of Canada, the court said yes. So even though they're in a public place, the school, but in a public place, people will still retain their reasonable expectation of privacy. Just because they're in a public place, it doesn't mean that they let that right go. And in this case, we have the Legal Education and Action Fund, which actually intervened to argue that privacy in this context has to be understood as a concept that protects the sexual integrity and autonomy of people, especially women and girls in this case, participating in public life, as they recognize that voyeurism is a crime that disproportionately affects women. These comments helpfully clarify that people do not abandon their privacy interests, and specifically their right to be free from unauthorized intrusions into their sexual integrity when they enter public spaces where they know they can be observed by others. And lastly, we have impersonation. Impersonation can lead to reputational damage and put a person at physical risk. We see abusers creating fake online accounts of individuals to spread false information and damage their reputation of the person they're impersonating. Abusers can also create fake websites impersonating victims in an attempt to ruin their personal relationships or destroy their job prospects. They may also send fake messages or create fake accounts to damage personal and professional relationships. Some abusers impersonate someone other than the victim survivor to glean information about the victim that they would not normally be able to access. Again, individuals can create fake online dating accounts and pretend to be members of the LGBT community to lure, extort, harm, or out them. And in other cases, impersonation has been used to trick women into situations of human trafficking, with social media often being used to target young Indigenous girls for human trafficking. The most vulnerable are often the ones targeted online, and studies have shown an increase in exploitation of Indigenous girls on Facebook in Western Canada.
Awesome. So now that Francesca has given a very thorough description of what some of these online sexual abuses are, we can turn to who is affected. It's important to note that this kind of violence can be felt and experienced by anyone. So not just women and girls, although we are talking about them a lot more. According to statistics, women and girls are most affected by online sexual violence. However, certain groups of people are subjected to this form of violence at higher rates and face qualitatively different kinds of attacks. So we're focusing on two groups or two communities that are subject to this type of violence more frequently. So first we have women, transgender, and gender nonconforming people with intersecting inequality factors such as people of color, the LGBTQIA2S+ community, and people with disabilities. So we know that they can face higher levels of online harassment and abuse compared to white, heterosexual, cisgender, or able-bodied individuals. Secondly, we see individuals in intimate partner violence situations. They're more likely to experience higher rates of technology facilitated violence or online sexual abuse at the hands of their intimate partners, like Francesca mentioned, for coercive control. It's also important to note that there are just individuals who don't meet patriarchal norms of masculinity, and so they are at an increasingly higher risk of facing this form of violence as well. As you know from being educators, the intersectional nature of technology-based violence is born out of research that shows online abuse and harassment aimed at racialized and LGBTQIA2S+ individuals. It often combines sexist, racist, misogynistic, transphobic, and discriminatory language. Individuals with intersecting marginalities face higher rates of online sexual abuse, and that is what is included with that. How a person experiences online violence will be inherently tied to other aspects of their identity, such as a person's intersecting identity factors will alter the experiences that they have online, influencing the ways they are attacked and the level of violence geared towards them. So for example, a 2012 study by the European Union Agency for Fundamental Rights found that LGBTQIA2S+ individuals were harassed and threatened online because of their gender expression and sexual orientation. They were also more likely to have their intimate images distributed without their consent or receive threats of outing to an individual's sexual orientation. As I mentioned previously, my research also looks at intimate partner violence and how online sexual abuse is becoming more and more prevalent in our family law system. Individuals who are in abusive intimate partner relationships are one of the more common targets of online sexual abuse, as I mentioned. Abusive intimate partners have used technology to stalk and monitor their partners and ex-partners, send insulting and threatening messages via text or social media sites. They can disclose humiliating information about their partners or their ex-partners online, and the monitoring of their partners' devices and social media accounts. So you often hear of people using technology to follow other people through Apple AirTags and vehicles, or being able to access webcams. So that all contributes to online sexual violence. The increasing prevalence of online sexual violence through technology is a serious concern for individuals who already have disproportionately suffered in violent intimate partner relationships, particularly because technology facilitated violence is also minimized as an insignificant form of abuse. And although it's becoming more prevalent in our court system to acknowledge it, it's still, the courts are very much behind in acknowledging this type of abuse through technology. Okay, so what are some of the harms? The harms caused by online sexual abuse are felt both at the individual level and at the systemic level. So we know that individual people can have their privacy invaded and their autonomy threatened. They can also experience psychological harms. They can feel fearful. It can limit their expression. And they can also face reputational, professional, and economic consequences. But on a broader scale, this violence also has systemic impacts because it reinforces inequality and maintains those discriminatory norms that limit marginalized and vulnerable people. It also maintains and reinforces patriarchal gender hierarchies and institutionally undermines the violence experienced by those targeted. And also, what we talked about before with victim blaming and victim shaming, it also reinforces that narrative. So for example, why is it that when an individual takes an intimate image or a nude photo, the question is always, why did you do that? Or why did you send that photo? It's not more appropriately asked, you know, to the person who shared that intimate image without the consent of the individual. So why aren't we asking, why did you distribute that? Why did you send it to your friends? Like, why do you think it's a good idea to send this around a locker room or show people or what have you? There continues to be a stigma around this, and we need to shift the attention onto the individuals who are truly in the wrong. So I'll touch on all of these points really briefly. So firstly, psychological and emotional harm. Online sexual abuse can take a serious mental toll on victims. The form of violence can be relentless and widespread, There's really no avenue for escape in some of these situations because the victim is always accessible through social media, text, or a digital device. Some live in constant fear of their abusers, often being exhausted from managing the abuse. And a lot of victims suffer severe mental health impacts, such as post-traumatic stress disorder, suicidal ideation, or a combination of all these psychological and emotional harms. Secondly, we're going to talk about privacy. So several forms of online sexual abuse involve invasions of privacy. Whether, as I mentioned, this is hacking to someone's online account, accessing their webcam, following them, listening to them, installing spyware on their phone. Privacy invasions are an essential component of online sexual abuse. Marginalized groups have not traditionally been fully protected by privacy norms and are at risk of privacy invasions specific to their identities, which includes sharing their intimate images without permission, race-based police targeting, or the unwanted outing, as we saw in the clip in Euphoria. In terms of safety, many victims have legitimate reasons to fear their safety, and that can be psychological or physical safety. The offline world is not separate from the online world. And I think a lot of people mix that up, or they don't see it for what it is. But victims do face very real world impacts when they suffer the harms from online sexual abuse. We have silencing. So the systemic impact of silencing reinforces patriarchal gender norms and roles, discourages people from taking up leadership roles, and reduces online content related to equality and human rights. Multiple studies show that victims of technology facilitated violence reduce their time online or alter what they post online in order to avoid this type of abuse. Women, transgender, and gender nonconforming folks should be free to participate in digital spaces and be in digital spaces without fear of violence against them. Finally, we have economic harms. Online harassment and sexual abuse has led to problems at work, problems at school, and financial losses. And it has made it difficult for some people to find a job due to the reputational damage caused by the abuse and increased stressors impacting work productivity. Okay, so we wanted to make sure that we got real students involved in the discussion. So with the help of OJEN, we created an anonymous forum for high school aged youth. Some of these questions we came up with ourselves. I don't know how willing your students are to participate. So we did have to create a couple of these ourselves. But a lot of these are real life questions from students and from high school aged youth. We hope that this presentation can answer some of those questions, but we do urge you to do more research and access the resources that we provide at the end of this presentation to learn more. We also have some helpful blogs and resources on the Reclaim website that you'll be able to access, and you can always reach out to us if you have any questions going forward. So we do understand that you are the experts of your youth and your classrooms, but we thought we'd create a little list so that you as teachers can have some practical information on where to start. We know that a lot of this information is overwhelming, but by following this list, we believe that you as teachers can remain informed and have information that is practical for real life situations. So all of these 1 to 7 can be applied across the board to what we spoke about. If you're experiencing any form of harm, whether it be online harassment, non-consensual distribution of intimate images, voyeurism, impersonation, extortion, we do want to remind you that there are resources available, so that's very important. In the third point there, when we talk about evidence, we mean document everything, so dates and times, write down URLs, screenshot those images, gather information about the poster, and save conversations and any threats. We do know that this may be difficult when it comes to your students, but if you can encourage that to make sure that they know to save that information, that can be really helpful should they choose to pursue a legal avenue of recourse down the road. So what can Reclaim do? A Although I am leaving the Reclaim Project and heading back to law school, Francesca will still be here. I'm going to pass it off to her.
So as Gabby says, Gabby will be going back to school, but I will still be here as the Reclaim lawyer, and the Reclaim Project will still be a collaboration between Spark Law and the University of Windsor. As mentioned many times here, we have a website with blog posts that will be posted, which will provide legal education and legal information. We also provide pro bono legal representation for victims of this crime. Our website has information on how to contact us, but OJEN will also provide our contact information so that you and your students can contact us directly about any questions or inquiries.
Awesome. So this is the last slide, and we've created a list of resources that you can access. Obviously, this isn't exhaustive, but it is a good starting point for you and your students. They are color-coded. I love a good color-coded moment. So blue is American-based organizations, red is Canadian-based organizations, and that dark purpley color are global organizations. So of course, you can also contact local authorities for immediate help, and if anyone is in danger. Thank you so much for listening to our presentation today. We hope that this was beneficial to you, and we're open to answer any questions that you may have.
Thank you so much, both Gabby and Francesca. That was a really informative and important conversation that we're having for our first session. I apologize. It looks now like the chat is open and available. So please, for all our attendees, if you do have any questions, you can either put them in the chat or the Q&A. There is a question in the Q&A right now, which we'll start with. And it says, if victims choose to pursue justice through the civil courts, are there the same opportunities for tools like restraining orders, etc.? So if someone chooses the civil route, can they also get restraining orders or other, I guess, safety measures in place?
Sure. So from a safety standpoint, there are things that are called the common law restraining orders, but for the most part, the restraining order is actually called a peace bond, and that's obtained through the criminal court. So if a victim is able to produce evidence that there's a reasonable fear for their safety, that's kind of how that the restraining order component can be factored in, and it is through the criminal court. So the civil court is more so financial compensation or vesting posts. So copyright, you know, if you take a picture, it's the courts declaring that that's your property and it can't be redistributed. So those are the civil avenues, and the restraining order, the punishment avenues are more so on the criminal side.
Thank you, Francesca. Another question that just came in is, does the age of the victim and accused matter when seeking redress?
So from the criminal standpoint, if we're talking about minors, we're talking about the Youth Criminal Justice Act. And then from a civil standpoint, if there's a minor that wants to pursue a civil remedy, they would need what's called a litigation guardian, because individuals under the age of 18 aren't able to be plaintiffs on their own in that sense. So there's no real restriction, but it's just different components that apply.
Thanks, Francesca. And another question that came up, I think it was in the student FAQs as well, and I was wondering if you could elaborate or speak a little bit more to, but how easy or difficult is it to actually get images removed from online platforms?
So it really depends, because a lot of the time we're dealing with, you know, these Facebook and Snapchat and Instagram and these big companies that if you just send them an inquiry, they're not going to answer. I know Gabby has looked at, I think Pornhub has just now implemented a system with facial recognition to have images or videos taken down from that website. But ultimately, the court order would make things a little easier in the sense that people a lot of the time people won't do anything unless a court orders them to. So it really does depend on what website. It also depends on the jurisdiction. So if it's Canadian based or if it's international, but ultimately a court order would probably be the best way to go about it, just because a lot of the time people will ignore inquiries or ignore demands until they're actually mandated by the court.
Thank you for answering that. So it sounds like a combination of the courts intervening, but it also sounds like technology is advancing a bit when you're talking about the recognition to help address this issue.
Yeah, so I mean, it kind of seems a little hypocritical in a sense, because they say, you want us to remove this video, well, send us a video of yourself so we know it's you. So it's not the greatest, and as Gabby's actually researched, it's very new. So I think people are just starting to respond to this issue. And a lot of these websites have no real avenue to respond to it. So technology is developing really fast, and recourse for this issue is not kind of catching up as of yet. And that's the issue that we're still seeing here.
Great. Thank you for that, Francesca. I appreciate the answers. And I think another thing that was mentioned or talked about was for teachers to help their students or anyone who's been impacted by this to preserve evidence. Can you just speak a little bit more to that, what that could maybe look like?
Yeah, so again, a little hypocritical, but taking a screenshot, for example. So if somebody posts a picture of someone else, taking a screenshot to prove, hey, this was posted, or maybe there's a text message conversation where the person says, I'm going to post this if you don't do this. Just ultimately preserving any kind of evidence to prove that harm has occurred. Writing down URLs, as we mentioned, just taking down all information possible, because if you're going to go to the police with something like this, you're going to need this evidence to substantiate what you're trying to claim here, and especially if there's going to be a situation of a restraining order, you want to have conversations of threats, or maybe even taking handwritten notes with a date, like a journal of some kind. On this day this happened, just to kind of keep track chronologically of everything that's happened.
Great, thank you so much for that. That's very super helpful. And it's been shared in the chat that OCT has had teachers do a sexual abuse prevention course. This I feel should be included. Thank you for doing this presentation for us. It was very well done. And at that time, I think we're close to wrapping up with our time here. So I just want to echo that thanks. We really appreciate your time today. We really appreciate the audience attending today. And I would just like to take a minute to share the screen one last time to share our upcoming summer law webinars. So tomorrow morning, we have a session on R versus Sullivan at 9:30 in the morning. This should be a very interesting topic about extreme intoxication as a defense. We also have in the afternoon tomorrow at 1:30, supporting youth without immigration status. We'll be joined by our friends from Justice for Children and Youth. The following day on the 31st, we have a session which is a little bit different for our virtual Summer Law Institute. This will be an interactive discussion. So we are asking people who are interested in attending this session to please send us an email, and we'll have the link ready for you to join. When we're in person, we always have a tour of Osgoode Hall. So we're excited that this session this year will be taking place virtually. And I've been told it's a more in-depth tour. So even if you attend in person, you will be able to learn a lot at this tour. On September 1st, which is the Thursday, we have the Justice Centers from the courtroom to the community, which should also be another interesting and informative session to learn about the new Ontario Justice Centers. Don't forget, on 5:30, we have the Hux Kitely Exemplary Justice Educator Award. So that's always exciting to attend, and as well an email link to follow. And then we conclude the webinar series with the top 5 significant cases of the past year. And we have Justice Lauren Sawson presenting this session, who always does a fantastic job. Again, a final note to this, to our speakers to say thank you. And of course, we also want to thank our funders, the Law Foundation of Ontario, and all our generous donors. And of course, all the educators and teachers who are taking time today to be here. We really appreciate you being us, especially when the weather is still so beautiful outside, although I think there's some rain predicted. I want to address a couple comments that just came in. Can we get a copy of the slides? We have recorded the session as well as the slides, so we will be providing that to you for all of the sessions. So absolutely, you can get a copy of the slides and the recording. There's a note here from Patricia. Police officers in Hamilton also do a great presentation on sexting. Ask your officer. So there's more resources available for teachers who are interested in these topics. And thank you again, everyone, for being here. We do have a short survey for attendees to fill out too. This helps us provide This helps us with feedback, so we are always looking for additional topics and how we can improve the Summer Law Institute. That will be emailed out to all attendees who are here today. Thank you again, everyone. Hope you have a wonderful day and hope to see you again at our additional webinar sessions. Thanks, everyone.